The amendatory process. You know very well that there are 2 steps in the amendment of the 1987 Constitution. The first step is proposal, which refers to the adoption of the suggested change by the agency or authority having the power to do that. And the second is ratification, the approval by the people of the proposed change in the Constitution. Under the present Constitution, a proposal may come from 3 different sources. First, it may come from Congress by a vote of 3/4 of all of its members. There has been, in Oxenia versus Commission on Elections, the Supreme Court said that Congress has full discretion to determine which mode to adopt in the matter of proposing amendments, whether it may sit as a constituent assembly or whether it shall call a constitutional convention for the purpose. True enough, the Constitution does not specify whether the Congress should sit in joint session or separately, and one of the major issues that has provided a lot of controversy is whether the 3/4 vote requirement should apply to each of the houses of Congress. Today, at least, we learn from newspaper reports that the new Speaker of the House of Representatives has admitted that there is need for the Senate and the House to vote separately on the on the 3/4 requirement of the Constitution. So I suppose this has always been our view, and this is apparently the consensus among a lot of people. Father Joaquin Bernas himself says that there is no need for Congress to adopt a preparatory resolution to sit as a constituent assembly because it is already vested with that power by Article 17 of the 1987 Constitution. And Father Bernas says that Congress does not transform itself into a different animal in order to be able to propose amendments to the Constitution. The source of a proposal is a constitutional convention. But a constitutional convention does not exist under the Constitution. It has to be called into existence by Congress. And the mode of calling it into existence is through 2/3 vote of Congress, or failing to obtain the 2/3 vote by a majority vote of Congress, provided that the issue shall be submitted to the people in a plebiscite. Mabanag versus Lopez veto is authority for the principle that a CONCON, once validly called into existence, occupies a status equal to each of the 3 branches of government. I have always advocated the calling of a constitutional convention because it appears to be the most democratic of the modes of proposing amendments to the Constitution. And on the assumption that the members of the CONCON are to be elected by the people, that is the second salutary feature of a constitutional convention, that the people themselves who will discuss the possible amendments are vested with mandate from the people through an election. But of course, Congress itself may, in its resolution calling for a constitutional convention, propose that a constitutional convention be composed of appointed members. There is nothing in the Constitution that bars this from happening. Then, of course, the third source of a proposal is a people's initiative. But in light of the Lambino doctrine, a people's initiative cannot be used to revise the Constitution. It can be used only to propose piecemeal, specific amendments of the Constitution. I was Solicitor General at the time Lambino was promulgated. As Solicitor General, I argued before the Supreme Court. I joined Lambino here as Solicitor General. So instead of supporting the position of the COMELEC, I supported Lambino, and we lost, of course. my position on the matter is, and this is the position that the CONCOM has taken, the power to propose amendments to the Constitution is the constituent power. The constituent power, like the legislative power or the executive power or the judicial power, rests in the people. Why can the people not exercise the power to revise the Constitution? If the people can propose legislation, if the people are the ultimate source of all these powers of government, why will you deny the people such authority? Well, of course, the Supreme Court has a different mind today. The second step in the amendatory process is ratification. The Constitution provides that any amendment or revision of the Constitution made by Congress or a constitutional convention shall be valid when ratified by majority of votes cast in a plebiscite, which shall be held not earlier than 16 or later than 90 days after the approval of such amendment or revision. And then, any amendment made through the people's initiative shall be valid when ratified by a majority of votes cast in a plebiscite, which shall be held not earlier than 60 nor later than 90 days after the certification by the Commission on Elections of the sufficiency of the petition. In your study of constitutional law, you must have come across the doctrine of proper submission. The doctrine of proper submission was laid down by the Supreme Court in a lot of cases involving ratification of proposed amendments under the 1935 Constitution. The doctrine of proper submission simply said that the people should be given enough time to mull over the merits and demerits of the proposed amendment. If they are given very little time, then there is no proper submission of the proposal. But today, since it's the Constitution itself that fixes the time frame when the plebiscite is to be held, we do not have any room for the application of the doctrine of proper submission. Then, of course, recall Gonzales versus Commission on Elections, where the Supreme Court said that a plebiscite may be held on the same day as a regular election. Tolentino versus Commission on Elections is instructive in that if the proposed amendment or revision comes from a constitutional convention, there can be no submission of the proposed amendments through piecemeal amendments. Recall in the case of Tolentino what happened. In 1970, delegates to the 1971 Constitutional Convention were elected. The delegates met in 1971, in June of 1971, and worked very hard. But after a year, after several months of labor, they had only approved one resolution, and that was the resolution reducing the voting age from 21 to 18. In order to assuage the people, the convention said, let us submit this particular provision to the people for ratification. Senator Arturo Tolentino went to the Supreme Court to stop the plebiscite, and the Supreme Court agreed with Tolentino. The Supreme Court said, no piecemeal amendments should be submitted for ratification where the amendments come from a constitutional convention, because the people deserve to know, to be given a proper frame of reference, that is, to know what the other provisions suggested by the CONCON shall be.